We're going to be talking about the Fourth Amendment, and it does not disappear at a roadblock. Now, I apologize for getting on so late, but I had to actually get something done today. Had a few other things. I'm actually going to be on first thing in the morning to also go over something that came across today that was very interesting. And it's in regards to landlords again and certain things that you can do to combat. I hate to use the word attacks, but you have landlords that do certain things that they don't actually know that's not within the law, and how you can be compensated for their misacts. So now, today, again, we're going to make our next move our best move. All right, there are moments in American law where the government tells you exactly what it thinks about your rights. Not in a press conference, not in a campaign speech, but in practice, in conduct, and it's way it chooses to treat you when it believes you fear gives them leverage. A roadblock is one of those moments because roadblocks tell you something very simple. It tells you the government has decided that suspicion can wait. It tells you the government believes stopping someone is easier than obeying the Constitution one person at a time. It tells you that if an official says safety loud enough, they expect you to forget the Fourth Amendment was written precisely for moments like that. Now, I want you to understand that's a lie. The Fourth Amendment does not disappear at a roadblock. It does not step aside because the police chief is under pressure. It does not become optional because the city is panicking. It does not evaporate because your neighborhood is struggling, because politicians want headlines, or because law enforcement found a shortcut and call it policy. Always understand that policy is not law. And a lot of times we're running into that, and people are they're just acquiescing to it. Now, the reason why I bring this up is because people love to say roadblocks are illegal, which is the dumbest thing I could ever give you. Now, this one actually comes from the District of Columbia, you know, where the White House is located at. In Mills v. District of Columbia, police created what they call a neighborhood safety zone in Trinidad, a neighborhood in Washington, D.C., you know, where the president is. They erected a perimeter, stopped vehicles trying to enter, and demanded their drivers prove one of a list of approved reasons to be there. If you could not give the government a reason it accepted, you couldn't go in. That is not a minor inconvenience. That is the state deciding movement first, justification seconds, and rights last. Now, this is why the episode matters, because a lot of people will listen just because somebody in a uniform is saying it to them. Now, I'm gonna give you a great thing, and then I'm gonna go ahead and finish. My father told me something that it was it was actually amazing to me, because one of the things he always told me, and if you listen to me long enough, you'll actually see. He said, "You have to understand there are two people in this world." He said, "No one cares about the dude in the baggy pants and big t-shirts, because that's what we wore, Chris Webber and all those, the Fab Five. Now would be the pants sagging or the tight shirts. Nobody cares about those. Goodness. Because you'll never let someone dressed like that get close to you." Said the biggest crooks are the ones who wear suits and uniforms, because you'll let them walk up on you and you'll believe the things that they're saying. And this is one of the things that comes from this, because they'll automatically believe what a police officer says, because a police officer is supposed to know law. Say that one more time. They're supposed to know law. They think that someone that goes to class for 12 weeks gets the education that someone that goes to school for 7 additional years gets. 12 weeks, 7 years. Understand this. Now, this is why this episode is going to matter, because most people have been trained to think in reverse. They think if a police officer says it's about crime, then the Constitution must bend. They think if an area has violence, legality becomes flexible. They think if a judge hears the word checkpoint, safety, deterrence, or special order, then somehow the burden shifts from the government to the citizen. That never happens. The burden always stays where it belongs, and that's on the state. Today, I'm going to show you exactly how to think about roadblocks, checkpoints, and the way a defense lawyer should think about them, not emotionally, not abstractly, but structurally. We're going to walk through 3 questions. First, what is a checkpoint in constitutional terms? Let me get back over there. Let me move this a little bit. I'm getting all out because I'm looking one place and forget that I have 2 separate cameras. Anyway, second, what legal tests control whether the checkpoint is valid? Third, how do you use this in court, in motions, in suppression strategy, and in the Supreme Decision brand to teach people that rights are not real unless you know how to assert them? That's right, I have a brand. Because once the government starts deciding who gets to move, who gets questioned, and who must themselves explain themselves without individualized suspicion, the issue is no longer convenience. The issue is control. And DJ, I actually bring that up tomorrow. Be sure you hit that super chat, Cash App, Apple Pay, hit something. Support the channel so we can keep going and keep growing. Now, but once you understand the steps in the roadblock, the questions that need to be asked, that's when you stop treating roadblocks like traffic. You start treating them like what they are, a constitutional fight. Now, let's start with the easy facts in Mills versus DC. The article explains that the Trinidad neighborhood in Washington had a history of violent gun crime. And in early 2008, there was a surge of homicides, assaults, and the whole nine, basically going through Chirac. Now, during the first use of the program, 951 vehicles were stopped, 48 were denied entry, and only 1 arrest was made, and that was for an open container. It was not for a drive-by shooting. It was not assault. It was not any of the violence that they were talking about. It was an open container sitting on a seat. And this is why you have to think about it differently, because they told you it was for one thing, but in actuality, it was something completely different. Why? Because reality matters, not someone's ideas. The law as is written matters, not someone's ideas. Because even on here, I actually did a show where I spoke about Carmelo Anthony and Austin. I can't remember Austin's last name, but there's so much misinformation about how that goes because people do not look at the actualities of what happened or what is being said or what is being shown or any evidence that has been presented to the public. Do we have all of it? No. But do we have what they're giving us? Yes. But in actuality, most people live up here. They'll create something and then they'll argue based on what they created, not in actuality. Because here's the bigger problem. When you accept the ideals of what someone says without going to look at anything, that's on you. This is one of the reasons why I tell people I give you these cases not for my benefit, but so that way it actually gives validity to what I'm saying. Because now you can go and check, and it's not some BS that I done made up. I didn't bring this off the top of the issue. But anyway, let's go back to the actuality. Because the facts are most people here stop. They don't pay attention to exactly what was going on, what happened. They give you, oh, well, in this day and age, well, when was the last time that happened? That's always the one question I always love to hear because it's so rare that I hear it. But every time I hear it, no one can answer when the last time it happened. You know why? Because it's rare. Or they'll go and say, well, it happened in 18 states over 2 months ago. Well, that's not here. You said here. So then why you worrying about 18 states over when or 18 months ago if it's not happening now? Because again, they live up here and then want you, then they'll project onto you, and then you're supposed to accept their projections, not what's actually happening. Now, the moment the government stops a vehicle at a roadblock, that is a seizure for the Fourth Amendment. That's not controversial. That's a baseline doctrine. The article begins there. Checkpoints are seizures, even if they're brief. That means police do not get to avoid constitutional scrutiny by making the stop short, routine, or administrative looking. They have to have a baseline for doing it. Now, and that matters once because you understand the stop itself is the seizure. The entire government narrative starts to crack. The state loves to reframe these cases saying, we only asked a few questions. We only checked for a legitimate reason. We didn't search the car unless suspicion developed. We were trying to prevent violence because I always ask people, because I asked the cop one day and it was kind of funny because he was like, well, we're attempting to prevent. I said, oh, where are the precogs? And he goes, huh? I said, you're telling me about Minority Report. You're Tom Cruise? And I asked us, who else am I looking for? I said, because if you're attempting to prevent something, that's not your job. So if the precog sent you here, when is it supposed to happen? Because they're the ones predicting the future, not you. Because it does not change. Jordan v. City of New England. And I don't trust anyone to know law that has been studying it for 12 weeks. And most of that 12 weeks, they haven't studied it at all. Now, the framing is designed to make you forget the constitutional event already happened because you're seized. The government already interrupted movement. Because again, this is another thing that people like to bring up. Oh, I have the right to travel. And then you use a case about welfare. But what happens is you have the right to locomotion. Locomotion can be walking. Your freedom of movement is locomotion. And a lot of people get that wrong. Because here's the thing, when we're talking about these things, the verbiage matters. And if you're not using proper verbiage in your writings, in your conversation, oh, I know my rights, you won't have to say that if you understand the words that you're supposed to use. Because like I tell you, I don't have to tell somebody I'm huge. Vision does that. I don't have to tell people I'm aggressive. My tone, my look, my actions tell people that. I don't have to say it. So if you actually know your rights, you don't have to tell somebody, you just exercise them. You show them through your actions. And most people miss that. And what happens is you forget that this is an adversarial system. This is a fight. That is what an adversary is. Now, if you're choosing not to fight, that's on you. But it does not change the law because the law doesn't care about you, it doesn't care about them, it doesn't care about a side. And as long as you understand how to apply the law, you're able to work within it. Now, because beyond one case, one city, or one neighborhood, because once you let officials normalize suspicionless stops, and this is done at scale through these types of roadblocks, they will keep moving the line. And I'm gonna give you an example because I always speak about Richmond County or Augusta, Georgia. And the reason why is because they had this team, or actually a team too, but they had a task force called Rolling Thunder. They kept pulling people over, and even now they glorify it on, I believe it's Police 24/7. And they talk about where they have it now. It's on Old Savannah Road. It's on down near, as we know it, the bottom. They have it in low income areas because when they moved it further up Washington Road, which is getting towards people with money that can hold them accountable, they were immediately held accountable for it. They immediately lost money because they went out and stopped the young man, and that young man immediately filed paperwork. Wow, here you go. Take that with you. Literally the same day he was given a ticket going through a roadblock. He took that ticket down to the federal courthouse, filed a nice little lawsuit, got him a little six-figure payday because the roadblock itself was illegal if it is not done for an actual purpose. It cannot be done for general suspicion or to prevent crime. It cannot be used in that manner. So it's always important to go through and even go and make sure if they're stopping you and they don't have a reason that, you know what, I have nieces and nephews, and when I watch them, what I do is I correct their behavior. I don't have to be loud, I don't have to be obnoxious, I don't have to even be physical, but I do correct their behavior because that is how you stop them from doing this foolishness. Because I had someone ask, how do you stop these legal encounters? You start holding the people responsible for them. I'm actually doing some videos now that'll be going up in the next couple of days where I'm talking about, because a young man brought up, why don't you just comply? Well, I'm going through why you don't just comply because I did a video, I want to say 2 weeks ago. People were complying in North Carolina. The police officer, he wasn't planting evidence on them, he was robbing people. Is he on TikTok? Is he on YouTube? He wasn't planting evidence on, he was stealing from them. Had another guy, Freitag. I actually thought it was 400. It was almost 900 people he planted evidence on or lied in a police report on. He just made stuff up. And then to come to find out, after I did my research, most of it was racially biased. You have to understand there is a difference between all of this. But at the end of the day, let me finish what I talk about with the roadblocks because all of this correlates together. Because even if you're not challenged to a point to where you're upset or anything of that nature, the challenge itself is something that should be addressed as soon as possible and properly. And that's where a lot of people are missing it. They're not doing it properly. So I'm going to lay out the checkpoint doctrine. And step one, ask whether the checkpoint is for a primary purpose. Oh, excuse me, what the checkpoint's primary purpose is, because if it's ordinary crime control, it is unconstitutional. And yes, that's City of Indianapolis v. Edmond. So if they're trying to prevent a crime, checking for DUI, checking if you have driver's license, Those are illegal checkpoints. That's not my words. That's the law. City of Indianapolis v. Edmond. Step two, if the checkpoint purpose is for something distinguishable from general crime control, you still do not surrender. You move to Brown v. Texas. And yes, I'm in Texas. And here are the three questions for that. How serious is the public concern? How much does the seizure actually advance the public interest? And how severe is the interference with individual liberty? All of these are things that you can go look because that is structure. This is the proper way in order how to address these. This is the first step in stopping foolishness. And oh, well, why are you making this difficult? Why are you not doing your job properly? Well, we're not infringing on your rights. And if you actually believe that, either you're telling me you're not qualified to be law enforcement because you don't understand law, or which makes you incompetent, or you're lying to me and you're willfully violating my rights, which are both of those are reasons to lose qualified immunity. Always understand, just walk them into it. Don't make this difficult. Because again, notice I didn't have to say, "Oh, I know my rights." All I said was, "Okay, either if you believe what you just said, either you're a liar, which makes you untrustworthy, as well as you're willfully doing what you're doing, or you believe what you just said, which makes you incompetent." I don't have to say, "Oh, I know my rights." He just understood I knew my rights because I told him what he was doing. Why? Because City of New England, or excuse, City of Indianapolis v. Edmonds, and Brown v. Texas, as well as Mills v. DC. I'm not making any of this up. These are things that you can go. I've actually said these several times. So if you're actually paying attention, you can write this down. Because one of the things that you do is make sure you understand how to set them up. You create the structure because every interaction has to be lawful. And if not, every interaction, you have an opportunity to stop the next one. And this is where good defense is already being built because you're setting it up on their cameras. Their acceptance, their continued movement is acceptance, acknowledgement. And these are the things that always I use everything they do against them, just like they would attempt to do that to us. Because anything you say or do will be held against you. Any and everything they do will be held against them. I'm not asking, I'm not pretending, I'm not searching. I am applying. Because you want to talk about pressure, that's what pressure is. I'm going to let you walk into it. I'm going to set them up. I'll throw that alley oop. Please catch it because I'm going to throw it. And I do. And the sad thing is, I've been doing this for a long time. So I do it unconsciously because, like I tell people, I don't play law. This is what I do when I go to sleep. This is what I do when I wake up. This is what I do throughout the day. Even the shows I watch are law shows. These are things that make me think and go deeper than what I necessarily need to. But it's because I understand these are things that are necessary because I can't teach you or give you actualities if I'm not able to think, if I'm not able to apply. I can't tell you how to think. I can't tell you how to apply if I'm not doing it myself. And a lot of times, what people do is they get into these pressure points because that's exactly what these stops are made to designed to do. They're designed to add pressure to you. And if you're not able to think through this, you're already behind the eight ball. Because even now, right? You know what? Let me before I go too deep on that. Let me go here. The article explains that under City of Indianapolis v. Edmond, a checkpoint is a per se unconstitutional if its primary purpose is simply serving the general public in crime control. In Edmond, the Supreme Court invalidated drug interdiction checkpoints, which would also include DUI checkpoints. And that's crucial because the court refused to let police use roadblocks as general investigative shortcuts. Again, not my opinion, not my feelings. Law doesn't care about me. City of Indianapolis v. Edmonds. Now, Mills v. DC. The DC Circuit said Trinidad Safety Zone checkpoint violated the Fourth Amendment because its primary goal was general crime control. When you have a checkpoint that's not looking for a specific person or, let's say, an accident, those are lawful reasons for there to be a checkpoint because they're looking for damage. They're looking for this person. They're looking for that person. They're looking for a specific car. That's when the checkpoint is lawful. Not because you have rolling thunder that just want to make sure they could possibly might be. All of those are illegal grounds, and all of those offer you an opportunity to hold them liable for doing things that does not defeat the Constitution. Now, this is your option. These are your choices because these are the ways you want to understand how to make them stop. This is how. Because less than 3% of people who get stopped by police actually challenge their tickets. I've actually done a podcast where I spoke to actual police officers here in El Paso, Texas, where they say, "Hey, I got a bunch of buddies because we have." They didn't call them quotas. They call them different. They call them something different. Just like everywhere else, they call them something different. But because what's happening is they will write anything on the ticket to charge you with something, especially if they say you're mouthy, you're fighting back, you're making their job difficult because you're not just cooperating and listening to their foolishness. Because they know that 97% of people will never challenge it. And you know what? Because you remember the Tommy Sotomayor, again, I go back to these episodes because I talk about this constantly. The Tommy Sotomayor question. That episode, I don't care what you feel about him, listen to the episode because it actually has some meat in it. Because at the end of the day, he asked the question because the prosecutor doesn't care. The police just writes anything. Prosecutor doesn't care. You don't fight back. Your defense attorney doesn't fight at all. And the judge doesn't care either way. So there is no legal defense unless you're the one initiating it. And you have to go all the way into it. So this is one of the things I talk about. Whenever you're going into a checkpoint argument, you argue Edmonds hard. You absolutely argue primary purpose. You expose the checkpoint as an ordinary crime control because you are the one that's responsible for your life and your well-being, your liberty. Because all of this, regardless of how it's going on, because I actually said something to a dude the other day, right? I asked, he was like, well, yeah, I'm doing this and I'm doing that and I did everything right. And I said, let me ask you a question. Did you file this specific thing with your attorney? He said, I don't even know what that is. I said, okay, cool. Did your attorney do this? He said, I had no idea. And I said, here's the problem. This is why people actually need to find out what these things are. Because if you're going to defend yourself, you need to know how to. Because the greatest example, you look at someone like, let's say I go out to box. Because a good example of that would be Adam 22. He go out, he gets in the ring, and he's in a combative or an adversarial position. But if his opponent knows how to box and throw them hands, and he doesn't, yes, he's in the fight, but that fight is meaningless on his behalf because he doesn't know what he's doing. And that's why I give you what I'm giving you. And also, I also make myself available for you because at the end of the day, there is something about knowing how to defend yourself. And then there is something about actually doing it. Because I say this all the time, everybody's strong with no resistance. I can go bench 350 right now if I don't have 350 pounds on the bar. You understand what I'm saying? I can go get that. Yeah, I'll bench 350 right now because I'm not benching 350. All of it sounds good until it's time to stand in there and look the devil in the eye. Because a lot of people don't understand this isn't fighting back isn't for everybody. 97% of people don't even try. And I even know I'm talking to the 3%. Because I actually had somebody tell me the other day that I should have a billion views and all. No, I'm not for everybody. The things I say isn't for everybody. The thing that I'm talking about isn't for everybody. Because when you're doing something for yourself and truly looking for independence and freedom, it's difficult when you're the one that has to go and get it. Because we're in a dependent society. You know, I actually love that because fear is a liar. I did a video called that and it just popped up on here. Fear is a liar. And that is the thing that drives most people fear because they're afraid of the bash. They're afraid of the gun. They're afraid what they could possibly might do because they got precogs too. But that's why it's an understanding whenever I do this. I don't get upset because I got, I only get 1,000 views on one video or 8 on like this live. When I get off of here, it's probably only going to have a couple hundred views. I don't care. I'm not for everybody. I'm gonna go to the next because it's gonna get 100 views here. It'll get 1,000 views there. And then it'll get another 1,000 on YouTube. And it's the biggest part of not Spotify and whatever. Because what's funny, matter of fact, before I go to my next point, what's funniest to me is I got my printout last week. The number one place that I am trending on is Vietnam. And I was like, that is crazy to me. But then I think about it. Why would I not be trending somewhere else? Why would I not be listened to somewhere else? Because the context of what I'm talking about isn't just law, it's mental stability. It's being able to stay calm under pressure and even creating a form of pressure and fighting back because the stance itself is either let's go get it. And absolutely with Tupac, that was one of the highlights of my life. I actually met him not too long before he passed. And it was great because I actually met him in Atlanta. But anyway, the whole point is I don't go after mainstream. I don't go after everybody. I go after I, I did when I first started my podcast, right? When I first started my podcast, I put up a little picture. I said, I don't want to be listened to. I want to be heard. I can have 1,000 or 1,000,000 streams and no one hears me. I'll have 1,000,000 people listen, but I have 10 that'll hear me. I'm good with the 10. I don't need I don't need the extra. I'm going through doing what's necessary for what I was blessed with. Cuz this gift isn't for me. It's for everyone else. But understand when it's time to go through this, I'm here. But now, let me go back. Brown v. Texas. Brown, not an overextended Edmund, is a better way to analyze deterrence, especially when it's coming to checkpoints. The court weighs the gravity of the public concern, the degree in which the seizure advances that concern, and the severity of the interference with your individual liberty. Basically, what it says, the government comes in strongest because they say there was violence, there was shooting, there was fear, there was urgency, yet in actual, excuse me, and I didn't get anything to drink. Here's the thing. Here's when we talked about that when I first came on. They set it up because of the gun violence. They stopped 950 plus people, one arrest. And it wasn't for gun, it wasn't for violence, it was for open container. But when you're going through the constitutionality of all of this, that's where the challenge comes in because they're just doing it because they know people don't fight back. I actually did a video, a live a couple weeks ago, where I used the words of a Chicago police sergeant. He said, "We police because they were arresting people because of their skin color." He said it. I agreed to it because it was what they were doing. He was arresting people for their skin color, even though they were licensed to carry guns. They were arresting teachers, doctors, lawyers. They were arresting people because of their skin color that were licensed to carry guns. But they were doing it in areas to which, because that's why all this came up, because they were arresting people with because of their skin color that actually had money to fight back and chose to fight back. They did it in low income areas because those people are less likely to fight back, or because again, people forget about the law of numbers never changes. 80% of Americans make less than $17,000 a year. I'm gonna say that one. 80% of Americans make less than $17,000 a year. So that means 80% of Americans live in poverty. There is nothing we're going to do to change that. So now they know those people cannot miss a paycheck. They can't. They can't afford to miss. Every time they take a shot, they got to hit. But when one disruption, that arrest, that ticket, that extra thing, now throws them off into doing something else. Understand that. It is designed to do that. There's an absolute design to do that. Because even I actually like that, DJ, but understanding, I always tell people this too. Do not allow someone to set up a trust for you that doesn't know how to defend the trust. And 99.9% of people that I run into have no clue how to operate, fund, or even enforce anything from the trust. Because again, that still has that 97% of people that do not fight back. They still have trust too. All of these things don't change just because if I have a Maserati, that doesn't mean I know how to drive. I have a Bentley, that doesn't mean I have a driver. Again, all of these things, just because it does not change these numbers, because it's designed to be that way. And the even in the context of this, people just accept being stopped at a roadblock and don't question anything and they don't push anything because I actually have people in my comments arguing with me, which is it is the funniest thing to me because I'm giving you the cases. You can go look them up. I give you actual numbers. You can go look them up. Like, do what you need to do. I actually had a dude tell me one day, he said, brother, he said, I listen to you a lot. I do this, I do that. He said, I put your information in the chat GPT just to check it. Or a Copeland law just to check it. And he said, and it's amazing the fact that Copeland Law or Chat GPT or some of these other AIs that they're catching up. And I kept telling, I said, now go back, over a year ago. I spoke about it's going to take about 3 years for it to catch up. But now, because they've remanufactured or reprogrammed the AI, is always understanding now it's going to respond how you program it, because it's going to attempt to start mirroring you and your questions and your thoughts. So if you're not asking the questions properly, it's not going to give you proper answers. And that's where a lot of people is missing the boat on this. Because even when I give you this, you can feed this into whatever AI you like. The AI is still going to be catching up. Right now, I'm still ahead of the AI because right now, what I'm giving you is coming from beyond 2008. Before AI, I was using actual intelligence. And one of the things that most people don't deal with is the fact that I even speak about a fear gene. Now, I wasn't programmed. I wasn't built. I'm the monster my father created. I wasn't built with the fear gene. Because in fact, in the fight or flight, it's fight. Like that's the only mechanism I have. I'm very confrontational about certain things. And then what I love is when you offer me the advantage off top. That's your ass, Mr. Postman. Because at the end of the day, this system is built. This is what I was built for. This is what my father was programming me for. These are the things that I grew up on. These are the challenges I accepted early. And this is one of the things that I want to talk about because, again, people will overstep because I very rarely ever hear someone speak about Mills v. DC. And when you talk about it, and you talk about Illinois v. Lidster, because I actually heard a cop use that one like 2 or 3 days ago. And what happened in Lidster involved a checkpoint designed to collect information from motorists known about a fatal hit and run that had already occurred. The checkpoint was aimed at finding witnesses or information about a completed crime, not stopping people because they were involved in an undetected or future criminal conduct. This is what you have to understand about the distinction, because just because the cop said that, people are like, oh, okay, we'll give you your license. That's not Illinois v. Lidster. There's a difference. Lidster, what I say, they have to be looking for something particular. They were looking for a fatal hit and run, so they were looking for someone with damage on a particular car. So understand, Brown v. Texas. Um, Mills v. DC. I went brain dead right then. Indianapolis v. Edmond. Because all of these are the things that we do to actually stop this mess from going on. Now, I'm going to start closing this up a little bit. So understand, this is going to get practical. If your case involves a roadblock, checkpoint, perimeter stop, safety zone, any of that, first, challenge the checkpoint in its inception. Argue that the stop was a seizure and required constitutional justification from the beginning. And what time is it here? It is 1:30 a.m. I'm on Mountain Time, the only city in Texas that is on Mountain Time. 2, expose the real purpose of the stop. Do not accept the government's label. Get paperwork, special orders, emails, briefings, because again, this is where we talk about a true detailed discovery, which again, Tommy Sotomayor question, go listen to it. I talk about these things, and even if you listen to the lawyers that have been on my podcast, they told you they've been doing this 5 and 7 years, and they have never filed a detailed discovery until I had given them one. Now, get the data. How many stops, how many searches, how many arrests, how many canine deployments, all of these. And then go to the fact that this was an intrusive stop. How long were the motorists delayed? What questions were asked? Were drivers required to identify themselves? Because that's the biggie. Because were they required to explain the definition? And 5, suppress anything they got. Because again, people think that a motion to dismiss is the same as a motion to suppress. And they think the setup is the exact same. No, they don't understand. Everything that you do has a process to it. Is in a design, it is in a system. These are the things that you need to go with. Now, the biggest takeaway tonight is a roadblock is not constitutional because it's called a roadblock. A checkpoint is not lawful because the police department uses word safety. Perimeter is not a legitimate basis for a stop because officers are frightened, frustrated, or politically exposed. The Fourth Amendment begins where convenience ends. And that's why meals matters. And that's why I did this again, because I spoke about it before, I want to say a couple years ago. But I'm speaking about it again because it matters. Because people are still being stopped at roadblocks and they're still just giving up their freedoms because they believe they have to, when in fact, that's when they are most shielded. It reminds us that checkpoints, stops are seizures. And it reminds us that the government must justify them. It reminds us that primary purpose is not a slogan, but a legal trap for unconstitutional crime control. It reminds us when the government avoids the trap, Brown v. Texas forces proof of a serious concern, proof of a stop advance that concern, and proof the intrusion on liberty is not excessive. There's a requirement because just like I tell you, when a cop tells you to do, they have to articulate. That's not my opinion. That is law. And anything else is BS. And that's all it is. And do not let them sell you a false choice. You do not have to choose between safety and the Constitution. You demand both because that's what they volunteered for. And because the day the state can stop everyone first and justify it later is the day rights become permissions. And permission can always be revoked. This is Supreme Decisions, and make your next move your best move. I'm out.